Well, hello. We went back to the days of radio today, didn't we? That's what I felt like, just sitting around straining my ears to listen. And it was so goofy at first. They just couldn't get the sound to work right. And it sounds like they went ahead and started it, even though the audio wasn't working. So we did miss the beginning of it. But it seems like he kind of made Aaron Nathan repeat what he'd been saying. So we didn't hear the usuals. We didn't hear, I thought for sure Michael Gottlieb would be there to try to defend his goofy motions, but instead we had Aaron Nathan, one of the local attorneys, do that. Well, I think Michael's local too. Yeah, it was kind of odd. We didn't hear from Ezra or Michael, but it was just ran by Aaron. Audio problems on purpose. You know what? I wouldn't doubt it. I'm not ruling anything out at this point. All bets are off. Anything can happen. And you know what? To be honest, it didn't go as badly as I expected it to go. What do you guys think? There were some disappointing moments, but overall, I don't think it went that bad. I was happy to see that Judge Lyman recognized that he just couldn't take the right away from Wayfarer to file this motion. It's in the federal rules of civil procedure that they have a right to file this motion. So for them to just arbitrarily say you can't file this motion is just nonsense. Oh, thank you, Mungeek. I'm just kind of perusing the chat a little bit now because once I get started reading, I don't know how much I'll be able to do that and not lose my place. You know, I scatter very, very quickly and easily. So I haven't listened to anyone else's content yet. I wanted to just say my own. That's what I prefer to do. If I'm going to cover something, I don't listen to anyone else first because I don't want to be swayed according to someone else's opinion. And so I haven't really done that. But then, there's always the worry that I'm going to get something wrong. So, but I think because I went into it with no hope of anything being fair whatsoever. So I feel kind of pleased. Then again, the most important ruling he didn't really do. He put that off a little bit. And so I'm not quite sure, but I feel not as bad as I thought. I thought I was going to be like screaming my head off this evening with you guys, like angry, frustrated tears sort of situation. But I don't feel like that. So it could have been much worse. Let me just say that. It really could have been so much worse. So, what do we have? What do we have today? Now, I'm going to put this up first because I believe there was a mistake made. This is my take on it because it does not make sense that he changed this meaning November. It really doesn't make sense because this is about Blake's response to the motion for judgment on the pleadings. He said November 19th and was the deadline for her to reply, and then their deadline to reply to her opposition, he said November 26th, but that doesn't make sense at all. In fact, she didn't even ask for that. She asked for October 27th, and I thought there's no way he's going to give her that. There's no way he gave her till November 19th. That just doesn't make any sense at all. Not only that, if you look at the schedule, summary judgment is due November 5th. So there's no way that there's no world that it would make sense that her opposition would be due after summary judgment. Because the whole point that they were arguing today is that this motion is meant to cut some of the stuff away before summary judgment. And then what doesn't get cut away by this can get cut away by summary judgment. So only October makes sense. But we'll see once the written order comes out. But Yeah, there's absolutely no way that November makes sense. That had to have been a mistake that nobody nobody noticed it at the time. Because 'cause I'm sure if wait, it's already on the docket? Are you kidding me? That doesn't make sense. There's absolutely no way that makes sense. So they have to prepare and submit a motion for summary judgment before she even all right, we're gonna just put that in a pocket somewhere because I can't even wrap my head around that, if that is in fact what he truly meant. So I'm sorry, I'm not gonna face that right now. I'm gonna put that away and say it was a mistake and it's gonna get corrected once somebody looks at it and says, "This can't work." Because it just doesn't make sense. The whole point they were putting to the judge, "This needs to be cleared up." And we remember he was asking, well, you know what? Let me get into this and we'll talk about why this doesn't make sense. So this is pretty messy, probably hard to read. I used to be I used to do transcription. I'm kind of rusty. I'm sure this is filled with mistakes, but I've got pretty much the entire conversation here. So, we're gonna skip through the unimportant parts, and I was highlighting it, but then I found some mistakes and I went back and fixed, so I lost my highlighting. But anyway, so the main points from this are that we did learn that, of course, Blake does intend to file a motion for summary judgment. We expected that. Of course, both sides. I mean, there was never a question that Blake was gonna do it. There was a question that Wayfarer would, because I didn't know if they intended to take everything to trial or if they were just insisting on taking the harassment charges to trial. We have that answered now because they tried for MJOP. So we know they do want to clear some of this stuff up. Exactly. Thank you, Mongeek. If this is not a mistake, this judge is truly a nincompoop. I I think it has to be because it just doesn't make sense. If this is not a mistake if this is not a mistake, I don't we're all gonna have to go to New York. That's just the end of it. We just have to go because this is ridiculous. But wasn't it funny? Were you guys listening at the beginning when the sound was messing up and people just started randomly talking? There was a TikToker, what is she, Katie and is it Kansas City? She just like starts talking and then somebody muted everyone. But I I thought of it too late. I was like, man, I should have said, is Blake all cozy up in Judge Lyman's lap? But I missed my chance and it got muted before did she? Jane says not actually Golden said she hasn't ever heard a plaintiff file summary judgment for SH. Yeah. And it's not gonna happen. I mean, that really has to go before a trier of fact, not just a judge. That really has to go before a jury. But I'm not surprised that she's doing it. Pam asks, if this isn't a mistake, what does it mean? It makes no sense. Let me pull this up again. I updated every time. That's why you see different colors. Every time you see a different color, it's because it's been updated. So the latest updates are in purple, and I put them in as October. But if you put this in as November, I mean, it's after everything. Literally everything else except for the joint pretrial order, which is as it sounds. It's an order that both sides they have to come to agreement on terms and submit it to the court shortly before trial. It's like clearing up the last of the things that are still under question. Everything else is done by then and they're still I mean the summary judgment's already done on November 5th and he clearly said that he does not want to extend summary judgment because it will mess up the schedule. So him allowing that's going to mess up the schedule even more because at that point everything is supposed to be neatly tucked away and everybody's just getting ready for trial. And with this particular trial, we've got a lot of holidays in there that the court's closed and the offices are closed. The time is shortened even more so. It literally makes no sense that those things would be ugh. See, I'm getting all tongue-tied over it all. That those things would be due after all of everything's supposed to be completely wrapped up at that point. The judge is still he's free to just make his rulings on summary judgment, and I don't think he would want to do that to himself because he's going to be going over summary judgment, which is going to be long because summary judgment includes evidence. So it's going to be piles of stuff that he has to look at. There's no way he's going to invite this as well. And then the response, November 26th, like that just doesn't make Thanksgiving time. And he wants that. Yeah, I believe you that it's on the docket. I believe you that, but I think they just took his words directly from the thing. I don't know. We'll see. We'll see. I can't face that right now, guys. I just can't. We're gonna put that away. And yeah, I believe you that that's what it said. I just think it's a mistake. Like they made a mistake when they wrote the order. Not that you made a mistake. But someone's going to bring that up because that's longer than she asked for. That doesn't make sense. So Blake was fussing, saying that she wanted expert depositions done before summary judgment, which does make sense because normally that's how it is. You may need those expert depositions, the testimony from the expert depositions, in order to include them in your summary judgment. Because summary judgment, like I just said, it does include evidence. Certainly, an expert's testimony would be very important evidence that you may need in order to be able to fully argue summary judgment. So that's what they're bringing up about extending the date of summary judgment because they've messed with the schedule so much that now let me go back to the schedule. So it used to be depositions were originally due August 14th. And then expert, that's like the regular fact stuff and the regular people depositions. Then expert discovery was supposed to go to October 15th. And let's see, and I think that included their depositions, their everything. Well, that all got moved, but summary judgment didn't get moved along with it. So what they're saying is we still have information coming in beyond that date that we might need in order to properly file a summary judgment. So that's what they're asking him for. And he says, let me see. No, he says that later. Okay, then the request for admission, and I talked about those the other day, and I felt like it was going to be granted, that they were going to be granted because they're a normal part, and I felt like they were just overlooked. Wayfarer did have an excellent point to say that you didn't even notice this for 6 weeks. Like, how are you going to bring this up now? You should have noticed this earlier. Yes, it was overlooked, but if you really wanted it, you should have noticed 6 weeks ago. So I figured it was going to get granted, but and this is another thing I was pleased with, that it's only granted in part, and it makes sense. I thought he was going to grant the whole thing, but he did limit it, which is kind of amazing. So I talked about requests for admission being basically, it's two things. The one thing I mentioned the other day is that you put questions to the opposing side and you ask them to admit certain things that you intend to make clear at trial. He does contradict himself. That you want to make clear at trial. And what it does is if you can get them to admit it now before going into trial, you can mark that off your list of points you need to make sure and make during trial. It also gives you kind of a peek into opposing side as well. And any little peek that they can get into each other's case helps them. Now, Wayfarer has been super quiet. There are very few things they've fought. Nobody knows what they've got up their sleeve, what they're planning. So I think their case is so buckled, buttoned down that they're good to go. They're not letting anything spill. And I think it's making Blake very, very nervous. And that's why they're like, uh-oh, we really need this. We want to know what they're going to admit and what they're going to fight and all of that good stuff. So they really want this. Whereas Wayfarer was like, take it or leave it. We don't really need it. The other part about, they called them RFAs, if you're wondering what they were saying, RFA, requests for admission. The other part of it is what they talked about is authenticating documents. That is kind of important because that can waste time at trial. If you bring something in that hasn't been authenticated, it's got to be authenticated then, and it does waste a lot of time. So the judge was kind of like, well, we might need this. So he did contradict himself, though. He did say that at times they don't bring that much to it, and then later he said they're important. But he was willing to let go the actual where they ask each other, do you admit this? He was willing to let that go. And that's a pretty big win for Wayfarer because they don't have to tell Blake anything. The only thing they have to do now is authenticate documents. And that's just administrative cleanup stuff that needs done, and get that out of the way. And that's how the judge felt too. He's like, get that out of the way. So this is another win I felt like Wayfarer got. So this made me happy because if they had to go through and answer all of Blake's questions, and we know there would have been 80,000 questions or 5 years worth of questions if she had been allowed to ask them. And now she cannot. He ruled on it. Cannot. This is all they have to do is the authenticate part. I know Cassidy hates to get stuff wrong, just trying to help where I can. Cassidy does hate to get stuff wrong. So, and I trust you, work in progress, that's what the order says. I'm going to wait a couple of days and see if somebody addresses that. I think the court made a mistake when they put that. All right, so they start addressing those RFAs. And so it's funny, Blake's attorney's talking about how they're just trying to save the court time, and they're just trying to shorten the time spent on trial. That's hard to imagine. That's hard to believe because they get paid much more money when they're actually in court than they do even. They already get paid a sick amount of money for all of these filings, but it's even more when they're in court. So I can't imagine, unless they're not getting paid right, or they're concerned that they're not going to get paid. I can't imagine these attorneys wanting to shorten trial time. I really can't. So they claim that's why they want to do it. It's not why they want to do it. They want to see what Wayfarer is willing to admit because it's going to make their preparation for trial so much easier. Still talking about RFAs. And then it's funny, he asks, did Wayfarer serve it on you? And they said no. And then we get into the motion for judgment. And I felt it started off bad. I'm going to say that. I agree. Gina says Lively's attorneys are just running up her bill. Oh, absolutely. I've said that for a long time. Like, I think her lawyers hate her. And yeah, that she's just a cash cow for them. Yeah, he was when he said we may not file. Well, I'm going to get to why that was so important. The point that he was making. Isn't that insane? Jesse and Max says Manette lead attorneys get just over $2,000 an hour. It's crazy. Can you imagine? That's what I think, Mamacito. I bet BL is a nightmare client, so they decided if they have to deal with her nonsense, they're going to get as much as they can. That's what I think. That is truly what I think, and what I would do. If I got stuck with that, I'd be like, you are going to pay if I have to deal with this, and my reputation will be forever scarred with this nonsense. You're going to help pay for my retirement. That's what you're going to do. I don't know, Gina. She asks, is it true that Ryan has said he's done paying Blake's legal bills and wants her to settle? That's the rumor out there, but the thing is, there's no way to know if this is true or not. I don't know how you would get to the bottom of whether or not that's true unless he came right out and said it. I would think so. I don't know. I mean, he might be the one driving this, because when you've got an ego the size of his forehead, that makes you do crazy things. I mean, the guy's made some money. There's no doubt about that. So he may be willing, just for the sake of, some people have to win. They just have to win and cannot see reason if you try to reason with them that you cannot win, you're not winning. You just can't reason with unreasonable people. But yeah, I saw that that it was a blind item that people were saying that, and it could be true. I mean, I'm sure he's not thrilled with how much money he spent, but I don't know if that means he's going to stop. Okay, so Kevin Fritz, and my goodness, that man is amazing. So some attorneys have the gift at writing excellent motions and briefs, but that's because you can sit down and you can take your time and you can be uninterrupted when you're writing a brief. But then when it doesn't always translate to the courtroom where there's a bunch of things going on. You have to think fast. You have to be listening to what everybody else is saying and thinking about what you're going to say when you stand up. So the two don't always equal. You cannot tell what an attorney is going to be like in court by reading their brief. And some people are great in court and not good writing, not good expressing themselves on paper. But Kevin Fritz, I've got to say that the way he presented himself today, he like took control. He was not going to be pushed around. And he was every bit as good in person as he is on paper. So if he's going to do some of the court, my goodness, it's these people don't stand a chance, because we've heard Ezra. I mean, she sounded shrill and angry and hysterical. And Michael Gottlieb, you know what? I don't even remember what he sounded like when he did. I feel like he was shrill as well. Like him and Ezra, I feel like are the same person. But Aaron Nathan did a little bit better, but geez, guys, clear your throat. I can't stand when people just leave that hanging there like that. But yeah, and not nearly cannot match Kevin Fritz for a second. Oh, did she? Not Actually. I can't wait to watch Little Girl Attorney and Not Actually Golden. I hope they've both talked about it already. But Cynthia says, Not Actually Golden said the same as you, Cassidy, about Kevin, that he sounds just like he writes. He really does. And that's not always so. So that's a huge deal when you've got that. That's a prize attorney when you've got that. But here he goes. I mean, he just lets it rip. So he says that it attacks, so this motion attacks Blake's own allegations and is based on her version of the facts and the document that she incorporates therein. So you have several letters from Blake, and you heard from her counsel stating that there's evidence that they would want to use in a post in opposition to the motion or in connection with summary judgment motion. And I feel like they've already written their opposition. They've had all of these letters they've sent to the court. Like, isn't that good enough? Why are you giving them more time anyway? But they haven't specified what evidence they could possibly use in an opposition to a 12C motion, and they can't. And let me explain why. One of the arguments we make is that the FEHA statute, which is the subject of at least 5 claims, does not have extraterritorial application, and it doesn't. It really, truly doesn't. Even in their little letters where they were trying to fight it, they were citing a bunch of California cases. The only reason an attorney would be citing a bunch of California cases to prove that their claims stand up in a New York court is if they could not find any New York cases to back it up. So anything that happened in California is absolutely moot. What they have to find, and doesn't exist, and I will die on this hill, is California using and applying and somebody prevailing on those claims under FEHA or California Civil Code. Now, judges will say, oh, we applied California law when they're dismissing, when they're granting motions to dismiss, because it doesn't even really matter. It's being dismissed. So you can say you opposed Russian law for all the good it does. You're dismissing the case. So it really means nothing. But to find a case that actually prevails, goes to trial, gets put before a jury, or gets ruled on in favor of in summary judgment that applies California law, you cannot find it. It doesn't happen. And I've been saying that, and people have criticized me for that. And they're like, oh, yeah, they do. They apply. Show me a case where they applied California law and it won, or went to a jury and the judge said, jury, use this California law to make your decision. It doesn't. Yes, I heard Gigi asked about the judge posturing about focusing on third parties. Yeah, I thought about it. I'm like, unmute, unmute. Hey, what about my protective order? Since you're so concerned about non-parties, sir. I really wanted to. Okay, so going back up to this, Blake admits in her own pleadings, and I love this part so much. She's a New York resident. She admits that all the conduct at issue took place in New York or New Jersey. In fact, she goes to great lengths in her second amended complaint to tie her damage and the allegations to New York. There is no evidence that Blake Lively could procure that would change her allegation. She is bound by her allegations. There's no amendment that would be granted in order for her to do a 180 and now say, well, wait a second, I live in California and the conduct at issue occurred in California and I was damaged in California. So none of the evidence that we have been exchanging over the last 8 months will change whether FEHA applies in this case. And I love it because he absolutely nailed it at this point. There was nothing to be said. How can you respond to this? That's about it. And you know what I loved the most? You guys who follow me and have followed me for a while, you know what I say is my most favorite piece of evidence. Do you guys know what I'm talking about? I say the most important piece of evidence in the whole thing. Blue Jean Baby, New York lady. Turns out that in fact is very important. I've always said it as a joke, but all of that nonsense that she put in her second amended complaint, and it was all about keeping Jed Wallace in. She just had to keep Jed Wallace in. That's what that whole entire second amended complaint was about. And look at it. It's her downfall. It is absolutely her downfall, because everything about it, and you'll see in the next bit of this argument, hinges on this whole New York thing. Yes, it backfired. And I just got to say, karma right here. We witnessed karma today. Yes, we did. Because what's going to be said to counteract this? Blue Jean Baby, New York lady. I should have put that on the thumbnail somewhere. Number one piece of evidence. And I've only said that as a joke, and now it's actually the truth. Furthermore, with respect to the retaliation claim, we allege that there is no temporal proximity, and temporal proximity means like the time is close enough between the alleged harassment or the protected activity, the report of it, which she admits in her pleadings occurred in May or June of 2023, and the alleged retaliation, which she claims occurred 15 months later in August of 2024. There's no evidence that she can submit that would change those allegations. Those are her allegations, and she's bound by them. And this was like closing arguments to me. Like, this was closing arguments good, because this is what closing arguments are meant to do, like to just shut up the other side. Guess what? Chicken butt. This was the guess what chicken butt moment. If I could have unmuted, I would have said it right there. Guess what? Chicken butt. That was the moment. That was chicken butt moment right there, because that's what he said. But look what happens. And this ticked me off. I mean, I went from like loving the moment I was in listening to Kevin Fritz to just like stone cold when Judge Lyman cuts in right here and goes, let me interrupt you for a second. And I'm like, here we go. He already had let Aaron Nathan run his mouth, didn't even have the decency to ask him to clear his throat before addressing the court. Let him run his mouth. And then Kevin Fritz starts talking and he's making too much sense. And so he's like, oh, let me interrupt. You're making too much sense. And what does he do? He starts to lawyer. This is what you would expect lawyers to say to each other, right? This is not what you expect the judge to say. The judge is supposed to hear both sides and make a ruling. Why did he jump in and start lawyering for Blake's side. So I was like, oh, this is going to be another one of those. It's going to be another one of those. It did get better for those of you who haven't heard it already. It did get better, but this was like I was hot. And it was really messy cuz his mic was bad. He was so much quieter than everybody else. So I'm not altogether certain what he said here. I pieced it together as best as I could, but it was really, really hard to understand. So maybe somebody took better notes at this point. But he says, I don't believe that's actually sound opposition from my recollection, is that pleadings constitute evidentiary admissions, but they don't go beyond that. And in particular, there's law, including from me and some higher opinions and very recent opinions about amending pleadings to conform with the evidence. So I don't know. I mean, you cited a proposition, and I'm not sure whether you're speaking loosely or not. What, like, could you just not let this guy finish? If you're not sure how he's speaking, shut up and let him finish. And then guess what? Chicken butt. You'll know for sure. You'll know for sure. Yes, the tone changes when the judge talks to Blake's attorneys. And that's why I say it's beyond just him letting her exhaust everything. Hold on, I got to get a drink real quick. Because the manner in which he speaks to them is so different. But he did do a little better this time. I think he's probably either heard some of the criticism or he's had people report to him some of the criticism about what we've been saying about how he treats the two sides differently. Are you guys hearing me? Sometimes after I mute and I come back, my mic stays muted for a minute. So let me know if you're hearing me. But I love Kevin just takes over again like a boss. Okay, good. He just takes over again like a boss and he's like, let me be clear. It was so good. Certainly, a party has an opportunity to bolster or amplify their pleadings, but I think Your Honor would agree with me that you can't do a 180. You can't say that the traffic light was green in your initial complaint and then later say it was red. In other words, you can't flatly contradict your prior allegations. And I know Your Honor cited some of those estoppel cases in your, and I didn't catch what decision he said, and you can't go back and rehear it. So I'm not saying that she can't amplify her allegations. All I'm saying is you can't do a 180 and change it. And surprisingly, the judge lets him keep talking. I was really surprised. Blake's been very clear when the protected activity occurred and when the retaliation occurred. And there's a 15-month at a maximum difference. And if you even want to say when she met with the Wayfarer parties in January of 2024, that's still 9 months. And there's been decisions from Your Honor and other judges in your court and the Second Circuit saying that's too far. And there are. I've looked them up. I showed you guys some of them. And some of them are like 4 months, 5 months, 6 months, too long to be temporal proximity. And some of them were Judge Lyman's own cases. So what's he going to say? With respect to some of the other claims for which we seek dismissal, they're based on privileges. Litigation privilege, fair reporting privilege. The statements that they attack made in the press are what they are. The words aren't going to change. This is so good, you guys. He was so good. He's like, the words aren't going to change. They're there. It's been done. You cannot rewrite history. Either the privilege applies from a legal point of view or it doesn't. So any amendment that she would try to do would respectfully be futile with respect to having to make these arguments once and not twice. Allowing the 12C motion to be heard and decided will narrow the case. Whether Your Honor dismisses 12 of her claims as we request, or 8 of them, or 6 of them, or even 4, it will certainly be narrower than where we are now. And that will make the court's job easier on any motion for summary judgment. It will make the party's job easier on any motion for summary judgment. It will significantly narrow the case. With respect to, I don't know why these all say AF. It's supposed to say AN. I think when I changed, I think I did some replace thing wrong. It's supposed to be A.N., Aaron Nathan. That's the attorney that spoke today in court. That we have enough to do. I love this part too. I'm not familiar with that type of opposition to a dispositive motion. As your honor can appreciate, we had enough to do when Blake moved to dismiss our claims. That motion was still heard and decided. We're asking for the same treatment here. And that's such a good point. You cannot use "we have too much to do" as a legal argument in a motion. It's ridiculous. And that's what he's saying. And he's like, we had too much to do too when she moved to dismiss our claims. And it wasn't one person's claims. It was multiple that they had to do. And they were already in discovery. It's such a ridiculous thing. And what does Judge do? Right away gets in there to defend. He's defending not just Blake, he's defending himself here, going, as to that, you didn't ask for an extension. Check that also. And I was trying to remember whether or not that was true, because I know there's been several times that Wayfarer has asked for, but been denied extensions. So I didn't get a chance. I meant to look this up and I forgot till I just now looked at it again. I want to know if that is true, because there have been so many times that they did ask for extensions and they didn't get it. So if anybody remembers, yes, Christina. Christina says that the Southern District of New York needs to be investigated. Yeah. Well, actually, I haven't had time to dive into it. There was an issue recently with the clerks of court, and it had to do with how they were assigning cases or something like that they were doing that they got in trouble for. Did you guys see that? I need to go back and look at it. We were champs on the popcorn. You guys were champs on the popcorn stream. What's that? What's that about? I cannot believe that man is still having to fight his subpoena. I just saw that his court date is set, and it's so far from now still. It's like late this month. Julianne says, yes, taking money to assign certain judges. That's it, Julianne. And what does that tell you about the judges? This is beyond the clerks of court, right? Because why would you pay a clerk of court to get assigned to a certain judge if there wasn't a good reason you needed to be assigned to that judge? Yeah, we need to get in there and do that research to see what's going on there. Yep, Jesse and Max. Good, you guys saw this too. A Southern District New York attorney paid a clerk over 10 years for favors. 10 years. Mm-hmm. Absolutely. That I've been saying since looking at this, and it's funny because I came directly from covering cases in South Carolina where they were talking about the corruption that's there, and it seemed like it was just crazy that kind of corruption exists. And then I come to New York and find all this stuff here. And I said the other day, it feels like it's mafia is alive and well. It really does. It feels like it's the mafia alive and well, still running things there. It's crazy. It makes me crazy. So then Kevin continues on. All I'm saying is that the defense, I love how he doesn't get ruffled. Like the judge says this stuff and he just like keeps going, just keeps plowing. All I'm saying is that the defense of the parties have enough to do, I don't think is a valid or legal basis for opposing a motion. Or, sorry, this is, like I said, it's really badly done. I didn't go through and proof it. Or not allowing parties to even have a motion be heard. With respect to Aaron Nathan's statements that the discovery of the depositions of our clients are ongoing, discovery's been ongoing for a long time. So we put together the motion after getting Blake's second amended complaint, in which she doubled down on her New York-based allegations, which gave us even more reason to seek an MJOP on the extraterritorial argument, Your Honor. So he's saying, you're saying we could have filed this earlier, but when? Because this was all new stuff filed in her second amended complaint that she filed on July 30th. You can't rule for an MJOP until after all pleadings are done. So that includes her amended complaint and Wayfarer's answer to that. So they couldn't have done this months ago. now is the time after they got all this, they read it all, they have to have time to process it and come up with the motion like this. You don't write this overnight. So that argument, he's letting him know your argument's ridiculous because there the thing that she changed about her amended complaint was all about New York. And so that opened up this motion. There's no way the judge can say that's not true. Because in all of her that entire complaint, the only thing she focused on was this bit about Jed Wallace, because she just really at all cost wanted Jed Wallace kept in here. And I think a lot of it is she doesn't want to have to go to court in Texas. And if she can't keep him in New York, she's going to have to deal with the Texas lawsuit where she doesn't have a daddy judge. These are pure questions of law, which is what an MJOP has to be. So Blake bringing in all this, well, we've got all this mountains of evidence, voluminous evidence that has nothing to do with an MJOP. These are purely questions of law. Did she plead this legal? Was it a legally sound pleading? That's all it is. There's no evidence they procured that's going to change any of the arguments that will be made in opposition to our motion. The judge says, let me ask you a question or two with respect to that request. And this was just like, I'm like, what are you talking about? Have you lost your mind, old man? Did you just sit here and lose your mind? Like, what are you talking about? Is there any prejudice to third parties if I don't decide your motion per judgment on the pleadings until I decide summary judgment? I mean, why would I accelerate a decision on the MJOP before summary judgment? Okay, what about the prejudice to the parties? It doesn't make sense. Why is it only about third parties? And not only that, why would you accelerate a decision before summary judgment? Because it's your job? And because it's in the federal rules of civil procedure that they have a right to file this motion, and you, as the judge of this case, have to consider it? How about that? No, I don't think she has autism. And you could tell he's like so taken aback. What's summary judgment? So summary judgment, we're not quite there yet. That comes in a little bit. So let me look at the schedule again so I get the date right. It is November 5th. So we had, do you remember we had the motion to dismiss early on? So a motion to dismiss, you tell the court after they've put their complaint in, and it's got all of these causes of action. And each cause of action says, oh, they did this to me, and they did that to me, and this to me. So with a motion to dismiss, you tell the judge, well, they accuse me of this and they accuse me of that, but they really don't have a sound legal basis to do this. And the judge will look at it, and without considering any evidence, just considering the complaint itself is true, they will look at it and see, have they actually done a good job pleading the case for these claims, these accusations? And if they haven't, he'll dismiss it. And if they have, it stays in. Then you get what they're doing now, this motion for judgment on the pleadings. This is just like a motion to dismiss. It just comes along later, after all of, because first you have one complaint, but then those complaints get amended and they can have extra exhibits attached to them. So this motion that's before the court now is like that motion to dismiss, but there's a little bit more to consider. We've had amended complaints and we've had exhibits to the complaints. And then he makes the same kind of decision based on the same thing, assuming everything in it is true and only ruling on the law. And then a summary judgment is after the end of all discovery, all the depositions. They will both, apparently Blake's going to do it too, they will take the evidence that they've got at that point and they can add that and say, well, we have this evidence that says that that's not true and this is true, and we can prove with our evidence. So this is a much more difficult thing, and they present all of that to the judge, and the judge will rule on it. And his ruling in that case will take the place of a jury if he grants it. So if it could end right there and never go to a jury, it could end with Judge Lyman, which is this absolutely horrifying thought. But if he grants it, that's it. There's no jury, there's no trial. So, but that's what it is. It's him considering all the facts and all the evidence by himself. So it can be appealed just like a jury ruling can. But his decision would be just like a jury's verdict. It has the same, it's equal. But it can be appealed. Yes, Copper Mountain, we need this to go to a jury. Because it's terrifying, that prospect, that he could rule on it and it never see the eyes and ears of a jury. So that's a summary judgment. Oh yeah, the third parties. He goes, with all due respect, because you could tell he's flabbergasted. He's like, Your Honor, I can only the prejudice of third parties, I suppose, could be. He just doesn't even know what to say. And then Judge Lyman says, he's the one who says, with all due respect, I know that you and Aaron Nathan are working very, very hard, but my question at the moment is really focused on third parties. But why? Yes, Van Zandt's considered a third party. Why is he focused on third parties? This is about the parties. And Calvin's like, when you say third parties, do you mean like non-parties, Your Honor? Purely people not associated with this case? Because it's such a weird question. Why are you? I really thought he sat there and lost his mind. And he says, yeah. I mean, if I just wait until I decide summary judgment to decide the motion for judgment pleading. But the whole point. Okay, I'm like, I saw Christina's comment. Please stay focused, love you, but you get very distracted. I was answering somebody's question, and they needed to understand that before we move on. So I used to be a teacher, and if there's one person in the class that has a question, you have to address that student to make sure everybody's learning. You can't just plow through and assume everybody's on the same page. So that's why if somebody asks a question, I will stop and answer, because they need it to understand the rest of the conversation. So so why does he want to save this for? So when he said that, I got scared, because one of the things that he could do is just say, we're not going to do this. We're just going to go to summary judgment. And I thought that that's what he was getting at here. I really did. And he still could do that. I feel like he came around afterwards, but it seemed like in this moment, he's like, I'm not going to do this. I'm just going to make you wait and do a summary judgment. And I was so getting really, really mad at the moment. And he says, well, Your Honor, of course, because when you put together motions for summary judgment, not only are you submitting declarations from parties, but you also have to gather declarations potentially from non-party witnesses. And there have been probably at least a dozen non-party witnesses who've been deposed. And in fact, there are probably even more people that we didn't depose, because there was a 20 deposition limit, which is more than usually. You only get 10, but because there were so many plaintiffs and so many defendants, he granted them more depositions than usual per party that we would go and get declarations from potentially. So all these people are going to be inconvenienced when and if you decide the motion under 12C. A lot of these claims will likely be knocked out, and we won't need to bother these people, and neither side will have to bother these people, which is an excellent point. The whole point of this motion is to clean a bunch of it up to make summary judgment more simple. Because summary judgment isn't simple for anyone, for either side or for the judge. So the judge should be thrilled at the prospect of knocking these out, because when he's considering all of these causes of action, and there are a lot, if he waits till summary judgment, he has to consider the evidence too. But if he knocks them out now, he doesn't. He just has to consider the law. So he should want to do this. And the fact that he's hesitant is very curious indeed, because what judge would not jump at the chance to do this job when it's much easier, when he doesn't have to take evidence into consideration and clear it all up for later? Yes, Copper Mountain. Summary judgment can knock out claims to never come back and let the rest go to trial. Yes, it can. So Wayfarer, they haven't put every single cause of action up in this motion. They've left a couple of them. They left 3. So they will still have a case. And I don't know what Blake has. He could decide in her favor with the summary judgment. If she submits one and he rules on it, he could. And Wayfarer doesn't have any cases left to bring against her. So that's all it would take to end the case right there. So you're saying that I should decide this motion for judgment on the pleading before November 5th? And he says, well, that's why, Your Honor, that's why I suggested moving back by a few weeks the summary judgment deadline. And the judge says, did you think this part irritated me? Yes, Alpine Spirit. Fritz has to explain things to him like he's in kindergarten. Before you came up with this idea that maybe you should file your motion for judgment on the pleadings a little bit earlier so that you would give the court time to consider your arguments and make sophisticated arguments. I'm sure I'll hear them from Aaron Nathan, and you are all owed consideration by the court of the question that she presented. Did you think, well, maybe I should make this a little bit earlier if I wanted this to be heard before I have to file summary judgment papers? After everything Kevin's already said, this is what this man comes up with. This is what this man comes up with. He says, we did put it together as promptly as possible. Your Honor, again, I just told you. Blake's second amended complaint wasn't filed until July 30th, in which she included additional New York-based allegations, which even strengthened our motion. Judge, so obviously you're saying that she would not have had the same motion based upon the original complaint filed by it? Duh. I don't believe it would have been as strong because when she amended her complaint at the end of July, she included even more New York-based allegations. And also another consideration, Judge, is what allegations should I look at that were in her amended complaint that were not in her original complaint, that are making material difference with respect to the strength of your motion? Yeah, that's obviously a mistake there. She includes a whole new section entitled "The Wallace Defendants Execute a Social Attack Plan in Collaboration with New York-based co-conspirators and knowingly injure Blake in New York." Blue Jean Baby, New York lady. And then there's a new paragraph attempt to tie the alleged improper conduct or misconduct to New York. So those are certainly new, Your Honor. And as we said in our papers, this is not late, given other rulings by other judges in this court and by the Second Circuit. And like he said, this was new stuff. They had a right to address the new claims in her second amended complaint. And that was only 2 months before this. That's not a long period of time. And the whole thing, do you remember? It was new allegations. She was trying to claim that because Melissa Nathan and Jennifer Abel were in New York and they were chatting with Jed Wallace and talking about hiring Jed Wallace. Now, they weren't in New York for business. They didn't go to New York to hire Jed Wallace. They were in New York because they were there doing a promotional event for the movie. In that time, they were also contacting Jed. They had contacted Jed from California. They contacted Jed later from Chicago. It was just by happenstance that they were in New York at one of the times that they contacted him. So Blake tried to claim that they contracted him in New York. None of them reside in New York or do business in New York. No business was done in New York, but because they were talking about hiring Jed when they happened to be in New York, that it made it New York. That's how ridiculous her claims were. So all of this was Blake's fault for trying so hard to tie it to New York. And now this is what she did this to herself. And because those were all new, none of that was in the CRD complaint. None of it was in the original complaint. None of it was in the first amended complaint. It only existed in the Second Amendment that she only filed 2 months ago, then they had what, like a month to respond? And then after the pleadings are all done, then you can file this MJOP. It is right on time. Why isn't Jed dismissed yet? I think to get a better deposition out of him, because if he's a non-party being deposed, it's different. Just like last time, it was when he finally said at a hearing that he had already handed in all of the discovery that was requested of him. That's when he finally got his motion to dismiss granted. And I mean, he does have to supply things, but supplying things as a witness instead of a party is very, very different. The judge says, I agree with you that I would, and this is when I finally calmed down a little bit. He says, I agree with you that I would not deny this motion on time. You don't have to argue that way. So this was huge. This was huge. He was not going to deny the motion based on Blake's biggest complaint, the timeliness of it. So this was good reassurance right here. And then Kevin says, okay, and Your Honor, to the extent that we press the court and have not given the court sufficient time, I do apologize. I think we provided a remedy for that, which is slightly moving some stuff back. And I'm sure Your Honor has already taken a look at our motion, maybe. And I'm sure that Blake has already decided, hey, this is how we respond. So we're confident that a ruling can be made before summary judgment motions have to be filed, and that upon the determination of our motion, there will certainly be fewer claims. How many is up to Your Honor, but certainly everyone's job going forward, including the jury in March, will be easier. And the judge says, let me hear from you with respect to summary judgment. Assume that I'm not going to decide the motion for judgment on things whenever it's fully submitted. Now, when he says this, don't take it like he's saying this is what's going to happen. He's giving them a scenario saying, okay, if this is the situation, if I say I'm not going to decide it, how are you going to argue that? He wants them to make a specific argument. He's not saying that this is his ruling, just to clarify that. Decide that before any date that you've got for summary judgment papers. Why should I extend the date for summary judgment? So he's asking him to argue his point so that he has a valid argument that he can look at and determine. They should have more pictures. I agree. Get Barbie and Ken out, for heaven's sake. I think I would oh wait, I accidentally put Judge Lyman. This is actually Kevin. I think I would extend that date, Your Honor, because once you've made a determination on our motion, it would reduce the claims at issue in summary judgment. If Your Honor's question is, why would Your Honor move the summary judgment deadline back, assuming that we won't have a determination, I think everyone on this call would agree that the current deadline of November 5th is not tenable, given that expert discovery is not scheduled to close until about 9 days thereafter. And that's one of the things I mentioned at the onset before we really got into this, is that expert discovery, the expert depositions, they are, what am I looking at? Yeah, the deadline that got moved to November 14th, the deadline to complete deposition of experts. But if you look, November 5th never got moved, the deadlines for motions for summary judgment. So included in your motion for summary judgment would more than likely be the testimony of your experts. So how are you going to still be deposing your experts 9 days after you've had to file your motion for summary judgment? This is very, very odd. And the original, let's see, do I still have the original deadline for when the experts were supposed to be done? I don't see it. I don't see that there. But that's okay. Kevin's going to talk about it. He's saying it's not tenable. We can't do that because we won't have our experts. How are we going to write an accurate summary judgment? And so the judge says, walk through your argument, not your government, argument with respect to that, because frequently motions for summary judgment can be decided without considering expert testimony, but it's not the usual. It's not really the way it's usually done. Expert testimony goes to things like damages that obviously can be important, but they don't tell you whether there's a genuine issue of material fact as to an element of the violation. And so Kevin says, well, Your Honor, as we contemplated in the case, the initial case management plan, any motion for summary judgment will be filed no later than November 15th. And then in the bracket, it says absent exceptional circumstances, a date 14 days from the completion of all discovery. So your default, the default practice is at least 14 days after the completion of all discovery. And given that the expert discovery was supposed to be completed by October 15th, it looks like the court had agreed that it would be at least, sorry, that's really messy. My transcription was, I've not done it for a while, so it was really, really messy. Several weeks, 3 weeks between October 15th, which is the end of the initial discovery date, November 5th. So it was always contemplated to be at least 3 weeks, Your Honor. And he says, I'm going to ask Aaron Nathan the same question. Both are going to have to give me the information. What kind of experts do you intend to proffer? And then he lets Kevin go first. So this is important. So he does, to make his ruling, he does ask them what their experts are going to be, because if they are the kind of experts that would have something to do with an important aspect to the summary judgment, then I think he might have ruled differently. But because of what they present, he does make the determination that it's not really crucial to a summary judgment. And I do partially understand that. So he asks, and then Kevin says experts on damages, which would not be crucial to summary judgment. An expert on PR and crisis management, that arguably could, because of the accusations of retaliation being made and their defense being, this is normal PR, this is normal crisis management, and the word of an expert would be helpful. So I feel like this is an error. You know, if he had just said damages, I would have said, yeah, he made the right ruling, because that's not going to affect summary judgment at all. But when he said PR and crisis management, I feel like that's a big part of their defense. Experts explaining, and the jury's going to want to hear that. I know if I were sitting on the jury, that's what I would want to hear. When you hear the things that they're saying, oh, well, Jed Wallace said this and Melissa said that, and you need to know, is that important? Is that normal? Is that what they usually do? Or is this awful? Is this terrible? Is this, was this retaliation? The average person who knows nothing about PR doesn't know. I don't know. Ashley knows, but I don't know. Roxanne asked, could you do a video just reading your transcript script? Let me see if I have time, because I've got a lot of stuff. I'm kind of backed up, and I leave tomorrow for Korea again. And so if I do get some downtime, I might do that. Yeah, I don't know if I can do that. I could just do a video of it, like not reading. I could just have the thing, and then you guys could just like pause it where you need and read it. I don't know how clear it would be. We could try that. Are you seeing it clearly now, like it is? I could try to do that. I mean, it's messy. It's got a lot of typos, but you can get the gist of it. And then he says digital space, bots, stuff like that. And then he says certainly on damages. So that whole thing about bots, most of us don't know anything about that. I know a little bit about it because of the conspiracy case I've been covering for like a year. And the guy actually used those. But before I covered that case, I had no idea. And I still am by no means an expert. And if I were to sit on a jury, I would want to hear that. So I feel like these are important. If you are going to, in fact, have an expert talk about this stuff, this would be a big part of your summary judgment. So this part made me mad. And then he says, well, the motion, Your Honor, there may be an element of the damages that we would seek that relief on, Whether the expert weighs in on that, I haven't put a lot of thought into it at this point, but it has always contemplated in the or suspected spam, leave me alone, in the order that the expert discovery would be finished, and a lot may depend on what experts Blake puts forward. So did you guys see in the thing she filed this morning, she's found a new thing about damages? It was that yesterday or today? It's all running together. She redacted the part behind it to make it look like I mean, well, they redacted it, so we don't know what it was, but I really want to know what it was. She's found a new way to claim damages, which is so interesting. And then the judge asks Aaron Nathan, what about his experts? And he says, and you know what, these guys, they're not even thinking about that stuff. So you could tell the question took them both off guard. Not to doubt that you would give it to me, but I would like an opportunity to respond to Kevin Fritz's points about the substance of some of the arguments in their motion. We contemplate proffering a handful of experts going to damages as well, experts in the digital space, the human resources space, experts who can apply non-reputational harm, causation, things of that nature. And I would think even more so on this, because she has a harassment claim, a workplace harassment claim. And these people are telling the judge that one of their experts is going to be a human resources person. Doesn't that seem like a very important part of a summary judgment claim in this kind of lawsuit? I think it does. So how did the judge end up ruling that it's not important to have these experts be deposed before summary judgment? It doesn't make sense to me. And he asks, causation, did you say? And he says, well, one thing I can say to simplify the inquiry as far as Blake's concerned, that although I can't promise anything, as I said, I don't anticipate that Blake will move for summary judgment on her affirmative claims. Of course, there are only affirmative claims of Blake's in this case on the basis of expert testimony, unless by some chance that expert testimony was uncontroverted. So from our perspective, that's one of the reasons why we're fully prepared to abide by a summary judgment deadline that precedes the last day for expert discovery. All right, let me move on. This is taking really long. Let me shorten this up a little bit. And then he moves on to the RFAs, and Kevin says, there's a deadline. It's come and gone. They didn't show good cause why they needed the extension, why they didn't ask for one earlier, why they didn't serve their request for admission. And when you asked him, the only substance he gave was to authenticate documents. And so they talk about that, and the judge ends up ruling, I'm going to just shorten this part because it's not that big of a deal. So it ends up just getting shortened. Instead of them having to answer these requests to admit, it's just about authenticating documents. So moving on from there, the judge asks, is there any other counsel who wishes to be heard on these issues? Aaron says no. And then he wants to ask Kevin one more question. Is there any reason why I shouldn't set the schedule for an opposition to your MJOP to be the date for the opposition to a motion for summary judgment on the assumption that you're not going to get an answer on the motion for judgment after the file, if there's not going to be any determination of the motion? And he says, off the top of my head, I would argue that that's going to duplicate the briefing or potentially duplicate the briefing. For example, if we've already addressed the extraterritorial argument in the 12C papers, then there's no reason for us to do that again in the summary judgment motion. Meaning, if you don't rule this in advance, then we're going to have to do these on summary judgment again. So what is the problem? Just rule on this quickly and eliminate. Otherwise, they're going to have to prepare all of these causes of action in their summary judgment if they don't have an answer back in time. And he's just trying to find any excuse not to do this. And to me, it's just he's trying to give Blake what she wants and rule this motion out and just skip right on to summary judgment. And he's saying you're wasting judicial resources. Setting the deadline for the opposition to coincide with the opposition for the motion for summary judgment makes good sense as an alternative to just denying it and effectively just rolling them into the same set of briefings. So he's saying, if you want to put it off, put the date off, but don't just deny this motion and roll it into. He's like, I'll take it late, rather than you just denying it. So we'll see what happens with this. And then Aaron says, I understand Kevin's point. There may be some duplication, but that was kind of our point. But Blake's point was stupid. It's not duplication. Because if things get ruled out in the MJOP, then they're gone and they won't be back again in summary judgment. And most of these things, there's no way for them to correct the fact that this stuff didn't happen in New York or in California, and that she's not a California resident. But most importantly, that they didn't happen in California. There's no way to correct that. So those things are going to have to be gone. There is no duplication. So of course he's still trying to fight for that. Kevin says, just one more point, Your Honor. Inherent in your question and in Aaron's response is that anyone's going to file a motion for summary judgment. They may not. Discovery is almost complete, but not yet. How Blake can claim that there's not, at a minimum, a genuine issue of material fact, I'm not sure, but I don't think it's a foregone conclusion that anyone would have a viable motion for summary judgment or file one. And this part made me so mad, because the judge is like, oh, Kevin, I'll give you an opportunity to take back those words, because I have no doubt from what I know that there will be a motion for summary judgment. But your ruling, sir, is not supposed to be based on assumptions that someone may or may not file for summary judgment. Do you remember when I was so angry at the word he used in his motion, in his order on the motions to dismiss, where he said, I assume that Ryan Reynolds believed his wife? Do you remember that? I'm like, you do not assume. And this is what he's doing again. You don't make this ruling based on what you think might happen in the future. You make this ruling based on its own merits. So this made me so mad. It doesn't matter if she's going to do that or not. It has nothing to do with the motion before the court at this moment. And he's trying to find reasons to make it. And now I'm getting mad again. And I can calm myself down. Okay. Unmad. Matcha latte. The judge sucks. I agree. And then Kevin corrects him. He goes, simply saying it wasn't a foregone conclusion. That's my point. And that's the way the judge is supposed to look at it. He's not supposed to be sitting there assuming anything. So I like that Kevin made that clear. Thank you, Dallas John. If only Wayfarer hired Cassidy, that would have won. No, those guys are, oh my goodness. I mean, Kevin Fritz, Ellen, Brian Friedman. I don't know. If they'd have let me be the judge, we'd be done with this case by now. It is crooked, Christina. It's apparently so crooked. And I'm sick of people saying it's not and trying to be defensive. And I mean, come on. How much do you have to see to finally admit it? Roses Wild says, I don't think the docket's a mistake. He was saying in the hearing he'd rather not move all the dates and ask Fritz what problem would he have to. The whole point, though, was to have it out of the way before summary judgment. I don't understand this. So that means they have to put all this in summary judgment too. So the judge isn't going to make an honest ruling on the pleadings alone. If he doesn't make his ruling till after he receives all the summary judgment, that tells me he's not going to make a decision based on pleadings alone. He's going to have all of the evidence from the summary judgment on his desk at the time he's supposed to be ruling on the pleadings alone. And that's messed up. That's messed up. Yeah, I know the order's on the docket. Oh, sorry, I clicked on the wrong one. But I thought it was a mistake too. Like, they got the order wrong too. Oh, that's messed up. Mm, now I'm angry. Then he asks Aaron, on the request for admission, I started off with the limited role that requests for admission have. Is there any reason why I shouldn't limit requests for admission to be limited to documents? Okay, this is back to the RFAs. We know how he decides on that. So then he grants the RFA extension to October 10th for both sides, but it's limited to authentication for documents. I like this ruling. They don't get a peekaboo into Wayfarers what they plan to admit or deny, which is beautiful. And so I'm glad about that. Who cares about authenticating documents? That's just going to save time in trial, all that boring stuff. So that's a good ruling. And then he does deny Blake's request, or all of them wanted an extension on summary judgment. So he denies that, which is just crazy. He denies that, but then he gives the other one such a long extension. That doesn't make sense to me. Doesn't make sense to me. So he tells them to keep the date of November 5th. He gives them, because Blake had also filed and asked for an extension of it to November the 12th. And he said, if the two of you agree on November 12th, write me a letter, a joint letter saying we both want this. Can we extend it? But he said, I will not extend it after November 12th. But that's still a week before Blake's motion is due. And you can bet she will file it at 11:59 on that day. And summary judgment will already be turned in. This is crazy. And this is where he says, a response to that motion November 19th with the reply date of the 26th. Those are my rulings. I'll put them on the document. That's supposed to say docket. And then he talks with Mr. Babcock for a minute, but that's all about Jed Wallace, and it's all separate, and it's not any kind of big decisions that are being made, other than getting a chance to hear the great Charles Babcock speak, which I absolutely adore. And he had some pretty good one-liners in there. But that's about it. That was it for today. It's not great, but it's honestly not as bad as I expected. I was prepared for much worse, and Blake did get denied. So that's very pleasing. And she didn't get the RFAs. That's very pleasing. So there is some good news out of it. I'm going to try to focus on that. But yeah, I'm very unhappy about that November. I hope that gets brought up. I don't know. It just sounds so crazy to me that gets turned in after everything else. Doesn't make sense. It's supposed to be decided before summary judgment. I mean, that's what he argued, that it eliminates the stuff. And for the third parties, remember he asked him about the third parties, and he said, well, some third parties are going to have to put in testimony for summary judgment if these don't get killed off. So what happened to that argument? And Jennifer Abel, oh my gosh, did you guys see, like, all but three of her the causes of action were dismissed against Stephanie Jones. It's disgusting. I can't even read it today. I honestly can't. I can't even read it today. I printed it, and that's all I could do. It's the good ones that she can amend. Okay, because I did see it was without prejudice. That means that she can bring that woman needs to file some criminal charges. Just call the police, call the FBI, bring on the criminal charges, because this is ridiculous. And then when you've got criminal charges, guess what? Chicken butt. No, then you've got a really strong basis for a trial, a civil trial on top of that, when you've got them in criminal actions. And it's a written record somewhere with law enforcement. It wasn't the worst outcome. That's true, Cold Fairy. All right, guys. Thank you so much for joining in. Thank you, Mongeek. I keep saying that wrong. Mongeek. And also Dallas John. Thank you guys so much. And all of you supporting the chat. And if you missed earlier, I showed an interview with my friend Stephanie, who has a podcast. She is investigating the case of a wrongly accused man. And as she announced in episode 5 of her podcast, it's been taken up by the Tennessee Innocence Project, which is a huge deal. And there's been some big movement in the case since she got involved. So all the attention, because there, and I might actually post it on my tab, a link to a video where the attorney for the Innocence Project is speaking before the court and begging them to reconsider. And the attitude, we think Lyman's bad, the attitude of one of those judges will make your blood boil. She does not even want to hear about this man. And so just listening to that makes me so mad. But here's the thing, the more attention gets brought to the story, this guy has already been in prison for like 20, almost not 20 years, but a lot of years, and more than 10. I can't remember exactly how many it's been, but the murder happened in 2007, and he was just wrongly accused. And the attitude that she has, thinking that there's an innocent man in prison, and she doesn't even want to hear it. So cases like this, we need attention brought to it, because it puts a little more pressure to the court to know that we're listening and we're criticizing and we're noticing. And yeah, so if you guys get a chance to go back and watch that interview, and I'm putting part 2 up tomorrow, to hear this woman is fearless. Memphis is one of the scariest cities in the country as far as crimes. And she's literally out there driving around and going to the apartment where the murder happened and talking to the guy in prison and finding the jurors who sat on his trial all those years ago and talking to them and talking to people who were in prison with one of the other accused. I mean, this woman has no fear. I was amazed. I was blown away. I mean, I sit behind my microphone and I get scared sometimes. And she's just like literally out there driving around Memphis. So anyway, yeah, Memphis it's bad. I helped her do a part of the research about the Memphis Police Department, and you will be shocked. You would be shocked at how bad it is. I had no idea. I mean, I knew Graceland was there. I've never been there, but I had no idea that that it was like that. Alpine Spirit, thank you so much. All right. Have a really wonderful evening, and I'll be back when I've got the strength to talk about Jennifer Abel. Good night, everybody.